Hey guys, welcome to the second lecture on IPR. So, basically, in the first lecture, we had discussed what IPR entails and we went into the introduction to copyright law. Now, we will be going into the cases that at least I studied, and I'm going to be going as per the modules that I studied. So, I feel like I'm saying as per and going a lot. But yeah, as per the way I studied it, it starts with Baker versus Selden, Walter versus Lane, and Canadian Limited something 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 versus Law Society. I have I've written the citation in the slides, but I'm discussing them, so don't worry about that. Uh, yeah, so basically, the beginning of copyright law, how I studied it, starts with the idea expression dichotomy. Now, the idea expression dichotomy is something we touched upon in the last lecture, and that is basically uh, it was formulated to ensure that the manifestation of an idea, that is an expression, is what is protected rather than the idea itself. So, as I said earlier, in copyright law, the idea is the formulation of a thought on a particular subject, whereas an expression is something that constitutes the implementation of that idea. So, an idea is like, oh, I have this idea for a book, it's great, but the implementation is actually writing the book, right? So, you can only protect the actual book that you've written and not the idea that you've thought of, right? So, that's what the dichotomy is. Um, Also, the next cases will be discussing the sweat of the brow test and the modicum of creativity, which is something you will keep coming back to in most cases on copyright, or even when you if you study musical copyright. So, yeah, it's all of these things are relevant to copyright law, and so you should make sure you understand them. I've tried to make it simple for you and break it down. So, yeah, let's get into it. Okay, so the first case is Baker versus Selden, and this is the citation, so you can look it up. I've given like a brief overview of the facts, issue, and rule, but I'll be discussing it, of course, more in depth. So, what happened in the case was there was this plaintiff, Selden, and he had written these accountancy books, okay, and in the books he had written this essay which explained the system of bookkeeping, right? It was a system that he had devised of bookkeeping, and there were his principles that he had, used to devise this system. So it was an explanation on how, on like some form of accounting. I don't know, like it's complicated, but that's all you need to know. So he had written this book, and then this other author, Baker, wrote a very similar book. And of course, why the reason this was an issue was because his book became way more famous and it was an improved version. So, of course, Selden then filed a case against him for infringement. But what Baker had done in his book is it was a similar book, but it just was similar to the sense that it used similar bookkeeping methods, right? But of course, the tables, the order of columns, everything was different. There were also many unique things, but he had used the same method, right, to achieve the same result. So then, of course, the court had to deal with the question of whether this amounted to copyright infringement. That is, can you protect a method or a type of accountancy? Now, the rule, of course, is that copyright provides for protection over um, copying of things verbatim, like word to word copying of text, and not of formats, methods, ideas, and all sorts of these type of things, right? So copyright is not a way to protect a method. It provides protection over copying, right? Copying word to word and formats, and not the idea. The only way you would get protection over the type of accountancy method would be sort of through patent law, but then that also would be extremely complicated. But that's the only way you can actually uh, get protection over an idea. So, yeah. And this is what the court held, and so the court said that there is no infringement. The reasoning again was that the copyright protection for a book explaining an art or system would extend only to the author's unique explanation of it. So if he had to copyright something, it would be the word to word essay that he wrote in the beginning that explained the system, but it cannot be the system itself, right? So yeah, it does not, it only protects the author's unique explanation and does not prevent others from using the system or the forms that the author has spoken about, right? So yeah, this is what this case held, and therefore it is a landmark judgment because it said that ideas are not copyrightable. And this case, though, is an 1870s case that was in the US, but it's still valid as law. Okay, so the next case is Walter versus Lane. And before I get into it, I know the picture is like weird, but I swear when you pictorial cues really help you remember, and that's something that helped me a lot in law school. Remember cases, because when you think Walter versus Lane and you see this photo, you'll remember what the case was about, and it's about the sweat of the brow test. So yeah, through this course and through like whatever courses I do teach, there's gonna be weird pictures, there's gonna be like cues, but I like to use these things to study better, and I think they do really help. So hopefully they help you. Um, and yeah, so basically we should get into the facts of this case. So this is a British case, and it was this case where the Earl of Rosebery had made a speech, right? And this newspaper, the Times, I think, they wrote his speech in shorthand. And what they had done is they had fixed the punctuation a bit, and then they wrote it verbatim almost in the newspaper, and they reported it. Now, it's a whole different case that the Earl of Rosebery had actually waived his copyright to this. Um, to the speech, but the question that came to court was still whether this is copyright infringement, or whether it is copyrightable as transcribed. So the rule in this case was the sweat of the brow test. The sweat of the brow test says that if you've done any labor, then you should get copyright protection. So it's an English standard, and it's sort of also referred to as a low standard because it just requires you to do like a minimal amount of labor to get copyright protection. So what the court had said was that since there was labor that had gone into making the speech readable with adding punctuation and all these things, and since spoken word was different from written word, it passed the test, the sweat of the brow test, and therefore, because there was sweat of the brow, because there was an effort made, in the it is that effort is enough to give copyright to the transcriber on the work, and give protection, right? So yeah, also again, since the original copyright was waived by the Earl of Rosebery, it wasn't that you know, important, but it laid down this law, this and reiterated this test that exists now. So this is sort of the British standard, and yeah, as I said, it's considered a lower standard as compared to at least what we talk about later in other cases, which are Indian cases and even this Canadian Law Society case. Okay, so yeah, Canadian Limited something something. I don't know the full um, name or what it is. It's really long, but this is the citation. So this is the last case that we'll be covering today, and it is this case where the Law Society was offering this photocopy service to researchers. So they could just like take these judgments and judgments that had been reported, right? So they could just take these judgments and photocopy them so that they could use them for research. And what the Law Society said was that, uh, sorry, wait. Uh, yeah, sorry, the Law Society said that it was for research purposes and it fell under the exception. But um, the Canadian Limited Society or whatever, they had sued them saying that you've infringed copyright because you have printed and copied these books and you're allowing for this to happen. So basically, you're copying books, they're not getting money for the reporting of judgments because no one is buying the real, material, they are photocopying it. So this is what they had argued. And the issue before the court was there a copyright on this copying of reporting of judgments, right? So was there a copyright on this? So, sorry, I said that twice. But the court first went into looking at whether there was a copyright on these judgments, and then whether in this case does this photocopying fall under any exception. Now the rule that I've just mentioned here is fair dealing because that's to do with the second half of the question, but with respect to the first half, they did say that there was a copyright. They said that the Law Society was sorry the judgments that were being drafted, that were being reported, they had editors who were adding head notes, they were doing selective work, and this selective work really added value to the cases that were being reported. So it is, you have to look and value the editing that has been done. So they said that we wouldn't have given copyright in a case like Walter versus Lane, but in this case, there is a different standard. And the standard that they used was modicum of creativity, which includes effort and creativity. So Walter versus Lane had just included effort, but here it says effort and creativity. So they said that in order to get a copyright protection, you must show the lowest amount of creativity and labor. But labor cannot be equal to creativity. You can't say just because labor has been done, there is creativity. So labor doesn't guarantee creativity, but there must be both, even if the creativity is a very, very small amount. So punctuating and paraphrasing and, writing certain things better, like in Walter versus Lane, wasn't creative enough for the court in this case. uh, this is what they had said, but then they said that in the particular situation, adding head notes and, you writing, about certain aspects of the case, so those things actually added value to the cases and they were creative, and so here it passes the modicum of creativity, and the law reporter actually had copyright in the works that were being published. So that was what was dealt with. That was what was said on the first question. That was the answer to the first question. But the second question was whether this fell under an exception. And that question was answered stating in the affirmative, saying that yes, it does fall under the exception of fair dealing. Because the court had said that in application of these factors to the facts, given the restrictions put in place by the Law Society for copying the materials, the library was acting fairly. The court also found that the library could rely on its general practice to establish fair dealing and was not required to show that all patrons use materials in a fair way. So, for research purposes and for educational use, which is also an exception in Indian law, um, what the library was doing was not violative of, I mean, whether it would have been violative of copyright, it fell under an exception to copyright, which is fair dealing. And yeah, so that is what this case said. The citations for all these cases are mentioned, so you can go through them. In case there are any questions, you can ask them in the comment section. What I've told you is basically the brief overview of what is essential to know in these cases, but there is also, of course, a lot more if you want to go into reading the judgments. And yes, I will see you next time where we will be discussing Feist Publications case, the Eastern Book Company case, and hopefully a few other cases to clarify the concepts better.